Well, I mean, you want to have your cake and eat it too. My concern with your position, it would be that it's going to put off the time when people can bring claims for access to evidence, because the claim is not going to be complete until you have the final decision by the CCA under your view, which helps you because you want to put off, the time at which this is, because otherwise the statute of limitations problem would be clear. But on the other hand, somebody who's there and is ready to go in federal court really won't be able to until the end of the CCA process, right? Because under your view, he has not finally been deprived of due process yet.
Your Honor, I would answer it this way. I don't think there's an exhaustion requirement. I think someone can exit the state court proceedings earlier. I think that the challenge, because the analogy to traditional due process claims I was discussing with Justice Kagan is saying there's not a due process deprivation until the proceedings are complete. Of course, what we're actually challenging here, and I think what litigants like Skinner would be challenging or Osborne would be challenging, are the requirements under state law that they must meet to show that they're entitled to the evidence. So it's not about necessarily the length of process, but about what they actually must show.
Well, I know, but the answer on the other side is, well, they're not going to know until they finally get an authoritative determination from the CCA, right?
So, Your Honor, I would say this. I think this is, I'm sure, why the court suggested in Osborne that it would be a good idea to continue pursuing these processes, and Skinner was, as the court noted, better positioned than Osborne was to raise that challenge because he had gone all the way to the CCA. I think that there are going to be practical concerns for litigants who try to challenge the state's procedures before they've actually tried to invoke them and seen what result they get. I think we could come up with hypotheticals where let's take the person who gets a ruling from the trial court and it says you're not entitled to the evidence, you failed these requirements. Okay, and it happens to be a state, unlike Texas, because it took a number of years, as in this case, to come up with, for example, a non-contamination requirement. Well, let's say this is 5 years from now in a state with plenty of appellate precedent on what Article 64 means. And they look at the trial court's ruling and they say, well, I know what's going to happen if I appeal. I want to go straight to federal court. So I think